All right, so we are back again with another reading. We're continuing with our case opinion of Judd versus City Trust and Savings Bank. And this is out of the Ohio Supreme Court. Now, last time I left off on this section here, section 1, but we read the first paragraph. So let's read on down some more. All right. The acts stressed in the above definition as constituting the practice of law are the performance of legal services for others. A corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. Trustees of Dartmouth College versus Woodward 4 Wheat 514L ed. 629, quoted in state ex rel. Krebs, Attorney General versus Thistle Down Jockey Club Inc. 114 Hawaii. That state statute 582590151 N.E.2d. It can function only through its officers. Agents are representatives. A salaried trust officer, page 87, or employee of a bank or trust company, regularly employed, whether a member of the bar or not, is as much an integral and essential part of its organization as the president or cashier. Corporations may not practice law. Therefore, when a trust company, through its attorney, employee, performs services for the customers or patrons in drafting wills, trust agreements, or contracts, and other instruments requiring the exercise of legal skill, such corporation must be held to be practicing law within the quoted definition from the Dorkin case. And this fact is not altered by the inclusion of the trust company in such instruments as a fiduciary. There can be no doubt that the drawing of wills and trust agreements for others, especially as a confirmed occupation, constitutes the practice of law to an important degree. Their preparation requires a considerable knowledge of the law and includes the imparting of legal advice to their creators. When a testamentary disposition of property is made by such instruments, they must, if unrevoked, be administered and sometimes interpreted by a court of proper jurisdiction. Furthermore, when an attorney, employee of a trust company, prepares legal documents of the character denoted for the patron or customer of the corporation. The latter is deprived of the offices of an independent legal counselor. Patently, the agency of the attorney employee is to his employer. The relation of attorney and client is that of master and servant in a limited and dignified sense. It involves the highest trust and confidence. It cannot be delegated without consent, and it cannot exist between an attorney employed by a corporation to practice law for it and a client of the corporation, for he would be subject to the direction of the corporation and not to the direction of the client. N.E.2d Operative Law Code 198 NY479, page 88, 483, 92 NE 15 16 32 LRA NS 55 58 13 AM ST Rep 839 842 19 and case 879 881 . In recent years, the question now engaging our attention has been before many of the courts of this country in varying forms, and the holding in most instances have been to the effect that the preparation of wills, trusts, agreements, and other instruments calling for the application of legal knowledge by a bank or trust company for its customers or patrons through its employees, who may be qualified attorneys at law, constitutes the unauthorized practice of law. People ex rel. Illinois State Bar Association versus People's Stockyard State Bank 34 ILL 462 176 NE.2d People versus Trust Company 180AD 494 167 NY Sup 761 N.E. Eastern Idaho Loan Trust Company 49 Idaho 280 288 P15773 ALR 1323 N.E. Otterness 181 Min 254232 NW31873A LR 1319 Kane Press Bar Association of N.D.V. Merchants National Bank Trust Company of Fargo 66ND 746268 NW 719 Compare State ex rel. Indianapolis Bar Association versus Fletcher Trust Co. Ind Sup 5 N.E.2d 538, and it would seem to make no difference that the bank or trust company is named as a fiduciary in such instruments. People ex rel. Committee on Grievances of Colorado Bar Association v. Denver Clearing House Bank 99 Colo dot 50 59 P.2d 468 State XREL Miller Circuit ATTY dot v. St. Louis Union Trust Company RCO dot 335 MO dot 84574 SW2D 348. Both the reasoning and the results in the cases cited appeal to us in the main as sound, and we find ourselves in accord generally with their pronouncements. It follows that the first question propounded calls for an affirmative answer, i.e., when state banks in Ohio having trust powers pursue the practices described for their customers and patrons, they are engaged in the unauthorized practice of law. Of course, this would preclude them from representing by advertisements, page 89 or otherwise, that they possess the privilege of engaging in such practices. It should not be inferred from anything we have said that the attorney for a testator or settlor may not confer with the bank through its officers and attorneys on any matter of mutual interest having to do with the appointment of the bank as a fiduciary. Nor do we mean to say that the bank is precluded from stipulating the terms under which it is willing to undertake the execution of the trust. And we will leave off here for next time. So I say peace, good night, good afternoon, good morning, and good day to you.